Here's something that'll sound wrong until you look it up. Your superannuation balance, the single largest asset most Australians will ever accumulate, doesn't follow the same rules as everything else you own. Not your house, not your bank accounts, not your car or your investments. And the specific way it's different catches families off guard every single day, in the worst possible moment, when someone's just died and the people left behind discover that what they thought was sorted actually wasn't. I spent 38 years as an accountant working with ordinary Australians across Sydney and New South Wales. Personal tax, superannuation, SMSFs, ATO disputes, Centrelink navigation, the full spectrum of what working families and retirees deal with financially. I retired from active practice in 2022. The reason I started making these videos is straightforward. After nearly 4 decades, I watched the same preventable problems hurt the same kinds of people over and over. And most of those problems weren't complicated. They were just invisible until it was too late to fix them easily. This one's the biggest. Your super sits outside your will, completely. Your will has zero legal authority over your superannuation, regardless of how carefully it was drafted or how much you paid the solicitor who wrote it. That's not an exaggeration for effect. That's Australian law. And the mechanism that does control your super after you die, the one that actually matters, is something most Australians have either never heard of, filled in once 15 years ago and forgot about, or completed incorrectly without realizing it was wrong. It's called a binding death benefit nomination. By the end of this video, you'll understand exactly what it does, why your will can't replace it, how it expires without anyone warning you, and what you need to do about it this week before it becomes a $300,000 problem for someone you care about. The reason comes down to a structural feature of Australian law that almost nobody explains clearly. Superannuation isn't held in your name the way your bank account is. It's held in a trust. The trustee of your super fund legally owns your balance, and they manage it according to the Superannuation Industry Supervision Act 1993 and the fund's trust deed. When you die, that money doesn't automatically flow into your estate. It stays with the trustee, and the trustee has to decide who receives it based on 3 things: the SIS Act, the fund's own rules, and whatever nomination you have on file. Your will operates on your estate. Super only becomes part of your estate if the trustee decides to send it there, and they only do that if you've specifically instructed them to, using the right form, filled out correctly. Otherwise, the trustee exercises discretion. They can pay your super to anyone they determine appropriate from a list of eligible people. They might consider a non-binding nomination you made as a guide, then completely override it if they think something else is fairer given the circumstances. That's not theoretical. That's exactly what happened in Katz versus Grossman, a NSW Supreme Court case from 2005. A father ran a self-managed super fund with his daughter as co-trustee. His balance was around $1 million. He'd made a non-binding nomination saying it should be split equally between his 2 children. His will said the same thing. When he died, his daughter became the sole trustee. She appointed her husband as the second trustee. And together they paid the entire super balance, all of it, to the daughter. The son got nothing. He took it to court. The court upheld the decision. The daughter and her husband had exercised trustee discretion within the rules. The non-binding nomination was just a wish, not a legal instruction. And the will had no authority over the super. A valid binding death benefit nomination, in place at the time of death, would have prevented the entire dispute. 14 years later, the Victorian Supreme Court heard Marcella versus Wareham. Nearly identical facts. A woman dies without a valid nomination. Her daughter, as surviving trustee, appoints her own husband as co-trustee. They direct $450,000 to the daughter, nothing to the stepfather of 32 years who was also the executor of the estate. Same gap, same problem, same structure. This isn't ancient history. This is how the system works right now. A binding death benefit nomination is the legal instruction that tells your super fund's trustee exactly who receives your balance when you die and in what proportions. When you make a valid one, the trustee must comply. No discretion, no judgment call about fairness, no flexibility. The nomination binds them in the exact legal sense of that word. Without one or with an invalid one, the trustee decides. You haven't directed anything. Now, superannuation law restricts who you can nominate. You can't just name anyone. The eligible categories are your spouse or de facto partner, your children of any age including step and adopted children, someone in a genuine interdependency relationship with you, someone financially dependent on you, or your legal personal representative, meaning your executor. That last option, your LPR, is the connection point between your super and your will. If you nominate your legal personal representative, your super flows into your estate, and then your will directs it. It's a legitimate strategy. It has its own tax implications we'll cover shortly, but it only happens if you deliberately nominate your LPR. Your will cannot reach across and pull the super in on its own. Here's the part that catches people who think they sorted this years ago. Most binding nominations offered by retail and industry funds are lapsing nominations. They expire 3 years from the date you signed the form, not from the date the fund received it, not from when it was processed. 3 years from your signature. After that, if you haven't renewed it, the nomination lapses. Most funds revert to treating it as non-binding or as no nomination at all. Your legally binding instruction evaporates on a specific date, and no one is required to make sure you noticed. Some funds now offer non-lapsing binding nominations which stay in force until you change or revoke them. If your fund offers it and you've set one up, that's the more stable position. But lapsing has historically been the default. The pattern looks like this. Someone consolidates their super at retirement. They're getting organized. They fill out all the paperwork, including the binding nomination. They name their spouse. Job done, they think. 3 years later, it's expired. The annual statement probably mentioned the expiry date. Better practice funds print it clearly. Others bury it in fine print. 4 or 5 years on, there's no current nomination, and they have no idea. If you're not sure whether yours is current, log into your fund's member portal right now and look under Death Benefit Nomination or Beneficiary Nomination. The expiry date should be visible. If you can't find it, call the fund and ask this exact question. Do I currently have a binding nomination in place? And if so, when does it expire? That specific question, in those words, will get you what you need. Even if you remember signing the form, even if you're certain you sorted it, there are 4 specific ways your binding nomination might already be invalid, and none of them require anything dramatic to have happened. Just a detail, a date, or a name. First, it lapsed, and nobody caught it. We've covered that. 3 years from signature unless it's non-lapsing. Most people don't track it. Second, the witnesses weren't valid. To make a binding nomination legally valid, it must be witnessed by 2 adults aged 18 or over, and neither of those witnesses can be someone you've named as a beneficiary. That second part catches more people than you'd expect. A husband fills out his nomination, names his wife, and his wife witnesses the form. That nomination is likely invalid. The named beneficiary cannot also be the witness, not as a technicality, as a legal requirement that voids the entire document. How much does it matter? In Gaynor and Associates PT Limited, a 2024 case, a member of a self-managed super fund died shortly after preparing both a will and a binding nomination. The nomination directed approximately $7 million in super benefits to the estate, but it had been witnessed by only one person, the member's solicitor. 2 witnesses are required. The binding nomination was declared invalid. The court had to determine distribution in a dispute that cost the estate significantly before anything was resolved. $7 million, one signature short. For SMSF members, the High Court confirmed in Hill versus Zuda in 2022 that the regulation requiring 2 witnesses technically doesn't apply to SMSFs the same way it does to retail and industry funds. But your SMSF trust deed has its own requirements. If the deed says 2 witnesses it is. Third, the person you nominated is no longer eligible or no longer alive. You can only nominate SIS Act dependents or your legal personal representative. A sibling who isn't financially dependent on you? Not eligible. A close friend who doesn't meet the interdependency definition? Not eligible. These nominations are invalid, in whole or in part, and the trustee's discretion fills the gap. The pattern that came up repeatedly in practice was parents who had nominated an adult child who then predeceased them. The nomination names someone who no longer exists. The fund needs to be notified. But most people in the shock of loss don't think of it. Fourth, you moved your super into pension phase, and the nomination didn't follow. When your super moves from accumulation into pension phase, an account-based pension, or a transition to retirement income stream, the account structure changes. Some funds carry your existing nomination across automatically. Others treat the pension account as a new start. If you made your binding nomination during your working years and then retired into a pension account without checking what happened to it, you may have a gap you don't know about. Australia abolished inheritance tax in 1979. There is no inheritance tax in this country. What there is, operating quietly in the background, is a superannuation death benefits tax. And it falls almost entirely on ordinary Australian families who didn't know to plan around it, while the ones who did know walk away clean. When super is paid to a tax dependent, a spouse, a child under 18, or someone genuinely financially dependent on the deceased, the death benefit is generally tax free. When it's paid to a non dependent, which includes financially independent adult children, the most common intended beneficiaries for most retirees, the taxable component is taxed at 15% plus Medicare levy. That's 17% effective on the taxable element. The taxable component is typically the majority of most balances. Employer contributions, salary sacrifice, and decades of earnings on both. ASFA's updated comfortable retirement benchmark for a single retiree is now $630,000. For a member with $500,000 in super, where the balance is predominantly taxable, which is standard, an adult child receiving that as a non-dependent is looking at a tax bill in the order of $85,000 before they see a dollar. That is not a tax on wealth. That is a tax on the super of ordinary Australians who contributed through the compulsory system their entire working lives, paid 15% on contributions going in, and are now asked for another cut on the way out solely because they didn't know to plan around it. The people who knew, the ones whose advisors treated super and estate planning as a single integrated problem, had already addressed it. A re-contribution strategy can convert taxable super into tax-free super while you're still alive. It's a legitimate provision in the legislation, not a loophole. It has its own conditions, contribution caps, and timing constraints, and it requires specific advice from a licensed financial advisor who knows your numbers. But it exists, and the families who didn't know it existed paid tens of thousands of dollars they didn't need to pay. One more assumption worth addressing. If something happens to me, my partner has enduring power of attorney and can sort this out. The honest answer in Australia is that it depends on your state, your fund, and the terms of the trust deed. Whether an attorney can create a new binding nomination on your behalf varies across all three. Some funds permit it explicitly. Many restrict it to renewing an existing nomination rather than making a new one. Courts have drawn that precise distinction. For most people, the safe working assumption is this: the only person who can reliably make a valid binding death benefit nomination is you, and the only time you can do it is while you're in a position to. There's one more layer most people don't consider. The majority of Australians with life insurance held through super don't realise their insurance payout is governed by the same nomination framework as their super balance. When life cover is held inside super, the death benefit, including the insurance component, sits with the trustee and is distributed under the same SIS Act rules. A lapse nomination affects the insurance payout too. Life insurance held personally outside super works differently. You nominate directly on the policy. The money goes straight to that person, bypassing the estate entirely. The pattern that repeated in practice was families expecting a meaningful insurance payout, discovering it had gone to the trustee's discretion because a nomination on an old, unconsolidated fund, one the member assumed had been rolled across years earlier, had never been updated. In March 2025, ASIC released Report 806, an investigation into how super funds handle death benefit claims. 10 major trustees, managing between them 38% of all APRA-regulated super fund assets. The finding? None of the 10 trustees monitored or reported on their end-to-end claims handling times. None of them. ASIC found that 78% of the claims reviewed had delays caused by issues entirely within the trustee's own control. One case in the report: a widow, valid binding nomination, $600,000 death benefit. The fund repeatedly asked her to provide documents she had already submitted. Months passed. This is the system, not a hypothetical, the actual system that holds your super and that your family will be navigating while they're grieving. A valid, current, correctly witnessed binding nomination doesn't guarantee the process will be smooth. ASIC's report makes that clear, but it is the one document that removes the trustee's discretion, narrows the room for delay and dispute, and gives your family a legal entitlement rather than a request they're hoping gets answered the right way. If any part of this felt overwhelming, start with one thing. Log into your super fund's member portal this week. Find the section headed Death Benefit Nomination or Beneficiary Nomination. Confirm whether you have a binding nomination in place, what type it is, whether it's lapsing or non-lapsing. If it's lapsing, when does it expire, and who it names. If you hold more than one super account, including any you haven't consolidated, check each one separately. Pension accounts often need to be checked independently from accumulation accounts. Once you know what's on file, cross-reference it with your will. If you've nominated your legal personal representative, make sure your will actually directs the money the way you intend. If you've named a person directly, Confirm they're still eligible, still alive, and still the right choice. For anything strategic, who to nominate given your family situation, how to address the super death tax for adult children, whether a recontribution strategy makes sense, take it to a licensed financial advisor and an estate planning solicitor working together. The two questions worth bringing into that conversation: how does my super nomination interact with my estate plan? And are there tax implications for my intended beneficiaries I should be addressing now? Those two questions will cut straight to what matters. Worth saying plainly, this is general information from my years in practice, and I'm retired, not a registered tax agent or licensed financial advisor. For anything specific to your situation, take it to someone who is. The form itself takes about 10 minutes. The planning behind it takes a conversation or two with the right people. What it costs to leave it unaddressed tends to be considerably more than both. That's it from me today. Thank you for watching. If this helped, share it with someone who needs to hear it, and I'll see you in the next one.